On February 12th, 2020, I submitted a motion that, in two separate cases, it was the same kind of motion, amended to be relevant to both cases that had been submitted concurrently. Case number 3 colon 20 CV 00113 N is the one that I'm looking at currently. Charity Colleen Crouse versus Judge Renee Harris Tolliver and Judge Ed Kinkeade. Now, I understand that when it comes to disciplinary actions, that there are certain sorts of situations that are requested for, shall we say, a kind of decorum. But however, I'm going to do this one specifically because the other case was Charity Colleen Crouse versus Texas State Senate. In response to actions that the Texas State Senate had taken in the last session that were unconstitutional, and the refusal of the judiciary branch to hold them accountable, and the refusal of the Texas State Senate to hold accountable the governor in actions that he had done under the Texas constitutional process. And I was arguing that there was jurisdiction in the federal court system in order to attempt a remedy at the violations of the Constitution that had been engaged in the state of Texas. But at the same time, I had attempted to file another case in the fall, and there were serious abuses of that process, and I attempted for redress by submitting a request for disciplinary action in consideration of the local rules of procedure that I have a copy of both in paper. I went through that process to have the same process replicated. That instead of being able to go through the process before the presiding judge assigned to the case, I was arbitrarily assigned to a magistrate judge, and even though I put in a formal refusal to consent to proceed before a magistrate judge, for some reason it was determined and allowed for this magistrate judge to continuously engage in the process. I was concerned for a variety of reasons, and I submitted a motion. I'm going to read that motion now. It was dated for February 12th, 2020. Motion for leave to amend a complaint. Charity Colleen Crouse hereby presents a motion for leave to amend a complaint in Charity Colleen Crouse versus Judge Renee Harris Tolliver and Judge Ed Kinkeade, case number 3 colon 20 CV 00113 N, as well as related case Charity Colleen Crouse versus Texas State Senate, case number 3 20 CV 00114 X, per Local Civil Rules 72.1. Briefing practice concerning objections to magistrate judge orders in non-dispositive matters. Plaintiff and representative Charity Colleen Crouse contends that thus far her efforts to represent herself pro se have been accorded not only an unfair disadvantage in terms of access to protections that an attorney would be afforded in connection with their client, but subjected to discriminatory and derogatory treatment by other legal professionals who do enjoy the advantages and privileges of designation as an attorney. The application for admission pro hoc vis requires reading of a case decision that describes the types of behaviors that an attorney engaged in a legal proceeding can expect from another attorney in that legal proceeding. Charity Colleen Crouse has been repeatedly denied this form of decorum by thus far every member of the legal community she has encountered, regardless of the jurisdiction under consideration, for going on 4 years. During this time, Charity Colleen Crouse has likewise been refused any representation, counsel, or assistance by anyone considered officially to be an attorney per membership in the State Bar of Texas or another professional legal society. The distinction between pro se representation and acknowledgement of one's capacity to advocate on behalf of another person pursuing exercise of rights to due process under the terms to which Charity Colleen Crouse has been subjected is a material difference in regards to comportment and behavior that can be expected of all involved in the proceeding. The last 4 years' worth of efforts to seek redress via the judicial system has proven this. Charity Colleen Crouse argued in her original leave to file motion for a new trial that one of the major points of contention was that use of her legal filings as derivative actions in regards to other proceedings, while she was personally denied any due process. Throughout this time, Charity Colleen Crouse has also been repeatedly denied any representation by an attorney, access to a prosecutor at any level of jurisdiction, or even a legitimate process by which to file reports with law enforcement or submit evidence. In the United States District Court for the Northern District of Texas alone, Charity Colleen Crouse has tracked how her efforts were disabused to merely continue perpetuating derivative efforts connected to legal proceedings and financial arrangements aimed to benefit others in denial of her rights to due process. These others include those whom may be directly named as respondents or whom were availed of the benefits of the theft of Charity Colleen Crouse's prior legal work in connection with her reports concerning illegal activity. Specifically in this matter, Judge Irma Carrillo Ramirez was informed the same day as the date on the consent to proceed before a United States Magistrate Judge, January 17, 2020, in case number 3:20-CV-00114X-BH, that there were conflicts of interest with Judge Irma Carrillo Ramirez being designated as the magistrate judge in the proceeding, as reflected in an email response sent to the email address connected to the clerk of the court. Charity Colleen Crouse explicitly identified how this specific electronic filing at that specific time fit the, quote, pattern of racketeering activity, end quote. By thus informing the court of this conflict of interest, Charity Colleen Crouse extended a professional consideration to Judge Irma Carrillo Ramirez that has not been reciprocated in the least during any current or prior effort of Charity Colleen Crouse to engage this or any other court. Charity Colleen Crouse did not receive electronic notice regarding case number 3:20-CV-00113-N-BH, but did receive notice via postmail on January 21, 2020, that case had been assigned to the same magistrate judge. This process conflicts with the decision alleged to justify Judge Carrillo Ramirez's refusal to acknowledge Charity Colleen Crouse's denial of consent to proceed before a United States Magistrate Judge via the order dated for February 11, 2020, that is now available on the electronic filing site. Charity Colleen Crouse received electronic notice per email that her application for admission pro hoc vis had been denied in both cases on February 9, 2020. Both of those original electronic documents have been deleted. Remonstrations that automation of cases for pro se litigants precludes a need for consent need to be evaluated accordingly. When Charity Colleen Crouse attempted to file for application for admission pro hoc vis, Charity Colleen Crouse also submitted information on refusal to consent assignment of her case to a magistrate judge. That Judge Irma Carrillo Ramirez was again permitted to provide a filing of record in consideration of Charity Colleen Crouse's case in violation of the appropriate local civil rules, as well as violation of the federal rules of civil procedure, compels consideration as to whether or not such an action was engaged with malicious intent. In fact, Charity Colleen Crouse was able to again identify how the notice from Judge Irma Carrillo Ramirez fit into the specific, quote, pattern of racketeering activity, end quote, to which Charity Colleen Crouse's previous legal filings had been subjected, and is exacerbated by their connection with the same elements to be considered in respect to Charity Colleen Crouse's efforts to file a request for disciplinary action concerning Judge Renee Tolliver and Judge Kinkeade. This calls into question whether Judge Irma Carrillo Ramirez was actually addressing the interests of the cases at hand as a judge or performing in a representative manner in regards to her colleagues, Judge Renee Tolliver and Judge Kinkeade. If it was merely a matter of automation and Judge Irma Carrillo Ramirez neglected to consider the case on its merits, then this provides further proof of the need to reconsider the treatment of cases by pro se litigants and their assignment to a magistrate judge, especially in violation of the rights to consent accorded to one under the law. No prior disclosure of Special Order 3-521 had been provided previously. Would a recognized attorney be required to submit oneself against his or her consent to a specific ascribement per an undisclosed special order? Or would it violate Rule J of Dondi Properties Corp. Versus Commerce Savings and Loans Association, 121 FRD 284, Northern District of Texas, 1988, in Bank? Charity Colleen Crouse challenges the recurrent pattern of racketeering activity that is prevalent in the proceedings thus far in consideration of disclosure of potential conflicts of interest and their capacity to be otherwise accommodated. Such actions are ostensibly the sort of cooperation that professional legal representatives are held to so as to mitigate against allegations of engaging unprofessional or illegal conduct in performance of their duties. The fact that such cooperation is not accorded to a person forced to represent themselves pro se is a material factor in this proceeding. It is on this point that Charity Colleen Crouse appeals the denial of her application for admission pro hoc vis. The concerns raised herein and in consideration of the other allegations levied in the specific filings that Charity Colleen Crouse submitted and that were assigned to Judge Irma Carrillo Ramirez assure that the issue is not in fact moot, but at the core of the arguments presented for consideration, and the original leaves to file motion for a new trial. Charity Colleen Crouse can be repeatedly denied legal counsel while attempting to exercise her rights to due process, and also to protect herself against efforts to extort her into agreement to cooperate with activities she is cognizant are illegal. Then the court at some point has to weigh the profundity of the refusal of those deemed certified to be accorded the privileges and benefits of consideration as a formal member of the bar against the constitutional question of rights to due process being denied without just cause. In this case, exercise of rights to due process have been repeatedly denied by those who are accorded the privileges and benefits of membership in the bar, a membership which explicitly sanctions the sort of treatment of a member by another member, yet to which Charity Colleen Crouse has thus far been routinely subjected in efforts to represent herself pro se. If a judge can refuse to address and comport oneself with requisite decorum in consideration of a case presented by one representing oneself pro se, then consideration must be given as to the reason why. If it is a matter of official membership in a professional society, asserting a certain expectation of professional consideration of a peer, or when affirmed to practice the law, as opposed to using legal filings for speculation on derivative matters, retaliation, or other areas beyond the primacy of the constitutional matter at hand, then the question is hereby called regarding the legitimacy of the bar itself. A good faith effort to engage the judicial branch of government and exercise a due process does not necessarily mean a subjugation of one's rights to the opportunistic gain of members of a bar association. This point was already raised as contestable per the decision provided in Judge Ed Kinkeade's order accepting findings, conclusions, and recommendation of the United States Magistrate Judge in support of Judge Renee Harris-Tolliver's decision in Charity Colleen Crouse versus Neuropsychiatric Center et al., case number 3:19-CV-02280-K. To seek to use the pro se filing effort for the benefit of consideration connected to other cases or efforts while dispossessing the pro se litigant of his or her constitutional rights to due process would be considered a violation of the rules of decorum for attorneys asserted by the United States District Court for the Northern District of Texas in Don D. Properties Corporation versus Commerce Savings and Loans Association. If no other means to exercise due process can be accorded to a plaintiff than to have access to representation that is permitted to perform in accordance with a select professional society, then it is requested that for consideration of the specific cases presented, Charity Colleen Crouse be granted the status of a bar member pro hoc vis, attendant with the assistance that would be available to a representative of the law seeking to mount a case for prosecution. This was February 12, 2020.